It's with a great pleasure that we accepted the invitation of Professor Vasco Pereira da Silva to participate in this Alpes Law Review number, and to whom we address our deepest thanks. Our purpose is to give a brief presentation about the Portuguese judicial model implemented during the Ancien Regime. Due to the extension of the topic, it will only be possible to point out the major characteristics, such as the judicial structure that comprehended both the ordinary and extraordinary courts, and in a second moment to list some of the deontological rules that marked the legal professions during those days and even nowadays, knowing that they are still mandatory as shown in several manuals of good practices. Under the expression of the judiciary of the modern period, we can immediately identify a complex political structure based on an anthropomorphic and organicist explanation. Among all the state purposes, the administration of justice got the first place. As in the previous centuries, justice was considered a virtue that neither the ordinary man nor especially the sovereign could ignore. In fact, this aspect was constantly remembered and required by the coeval juridical literature. Apart from the philosophical approach, the centralized state, now understood as sovereign, became structurally more complex and specialized. The number of judges raised, mainly among those who were nominated by the king, that aimed to extend all his magistrates to the entire country, situation that remained impossible to achieve until the eve of the liberalism due to the maintenance of the manorial and ecclesiastical jurisdictions. In other words, the simple medieval archetype was replaced by a numerous one composed by boards and councils collegially formed that could also apply justice both in first and second instances. To a new set of political institutions were also recognized jurisdictional competence, allowing us to identify an enormous group of privileged jurisdictions that increased exponentially until 1820. These new institutions, like the Overseas Board, the War Council, the Board of Commerce, the Royal Censorship Board, or the Board of Consciousness, considered as the most original example of an administrative institution established to deal with aspects of the king's consciousness, as well as the Inquisition, were now added to the ordinary courts that also suffered several changes. If we take the case of the two courts of appeal established, the first in Goa in 1544 as the first high court created overseas, followed in 1609 by the creation of a second instance court placed in Brazil. We remind that the courts of appeal addressed to the African territories were only conceived in the second half of the 19th century. But as we were saying, before the end of the 16th century was established another appeal court, now in Oporto, in the year of 1582, in the context of the Spanish reforms. Carefully, the legislator assigned a regiment to every single institution, which complemented the rules comprised in the official compilations entitled ordinances. It is important to emphasize that all these legal texts aim to reach a perfect justice whose model rejected all sorts of vices. This kind of reasoning was also claimed in the political courts in 1641, when the representatives of the nobility stated that the right administration of justice makes the kingdom stable and everlasting. Thus the legislator determined that every single judgment, apart from being motivated, should be given according to the law. That is, a so-called fair decision was totally incompatible with the admission of false evidences or the misunderstanding of the legal texts. These practices were totally forbidden, and once committed, very hard penalties could be applied. Moreover, other statutory aspects were under the attention of the legislator. In this situation, we can name the judges' salaries, but above all, the requirements related to the beginning of the judicial career, the provision of vacancies, the judicatur's control, and the progression of their cursus honorum. When we deal with the public offices, and in specific case of the Crown Justice ones, during the period of our analysis, two universes or groups must be defined. They correspond on the one hand to the scholars and on the other to the illiterate ones. In the first group are comprised the bachelors in civil law or canon law who after 1541, that is, 4 years after the latest university reform, were the only ones to be accepted for the royal judicial places. Once finishing their degrees, they could enroll to a specific exam that enabled them to the magistracy. Having passed this exam, they were considered licensed and were nominated for triennial periods in order to apply justice in the name of the Crown. For being reappointed, they should be inspected at the end of each judicature, regarded as good to continue this office. For this specific understanding, the Desembargo do Paço, a political and judicial institution, considered by the Portuguese scholars of the 18th century as the most important court, was the responsible institution to do this sort of inspection. If the inspection detected some sort of misconduct, the judge was immediately liable, and the specific punishment was addressed to him. Among other requirements, we can also point out physical aspects that prevented deaf, mute, or blind men from being accepted. Non-Christians, clergymen, nobles, and of course women were also excluded. In addition to the intellectual, social, religious, and gender requirements, it's also possible to name moral ones like honesty, probity, prudence, rectitude, wisdom, and a moderate conduct. If this group can be classified as the erudite one, knowing that they were the ones that would compound the high courts, the judiciary coped with another one, known as the ordinary judges, where we can find non-bachelors and, most of the times, illiterate individuals elected locally. The latest were tolerated by the former ones, although their criticism and haughtiness were very well known. Accused of arbitrariness, absence of knowledge, partiality in their own judgments, their work was often disregarded and shamed. Of course, that the authors of these negative judgments were undoubtedly the scholars or other professionals with previous juridical instruction. The same sort of rules were addressed to the lawyers that had to apply to an exam at the high courts to practice law there. Both in the lawyers' group was possible to identify the so-called perfect professionals in opposition to the inadequate ones. Those ones deserved the name of cheaters, deceivers, or pettifogging lawyers. To conclude, we don't resist to quote Jerônimo da Cunha, a famous Portuguese author from the 18th century. According to him, every single man had three sort of enemies he had to fight against, the world, the devil, and the flesh. And by being a magistrate, one should add three more, and they were the notaries, the lawyers, and the attorneys. All these rules got an intensive attention from the literature in general, and mainly the juridical literature that did not hesitate to list even the books that each lawyer or judge should have in their own library in order to be recognized as the proper and well-prepared ones. The explanation for this goal was only one: the achievement of the perfect justice. I do thank you for your attention, and I'm at your disposal. Thank you very much.